there's a way in which my talk, and also this topic was, as I recall it, last spring was kind of assigned by Craig, I'm actually happy to do it. It strikes me that would be a really, but for the fact that one of my students is here, it would actually be a really great exam question. And there's a way in which the answers to this topic, copyright and fair use in classroom instruction, are both very easy and also very difficult, to the extent that the law hasn't kept up with the technology. I hope I'll make that clear as I make my way through this. There's also a way in which I'll be talking very specifically about something that is kind of beyond what's already been talked about today, but in some of the things I'll be talking about do dovetail with what we've been talking about today in terms of IRs and interdisciplinary scholars commons and learning commons kinds of spaces. I'll try to respond to those issues extemporaneously, and I'd actually be really interested in talking about them in the Q&A, because we actually struggle with those things at IU Bloomington because the law has not caught up with technology. So the questions I had for Todd and Stacy, for example, were very much in my interest in finding out how people grappled with issues that we're also working with. So Q&A for me would actually be, I'd welcome a conversation about some of these issues. So to jump in, the current Copyright Act was adopted in 1976 and became effective in January 1st, 1978. It had actually been in the works for 22 years. So to the extent that classrooms still look like they did, like this mid-1970s classroom, the Copyright Act works really well. There's lots of coverage there for the kinds of traditional teaching and learning activities that still take place in classrooms. So to the extent that we read texts, whether they're fiction or nonfiction, look at art, watch films, that's all possible, easily done, and accommodated under the Copyright Act. To the extent that classrooms increasingly look like this and involve spaces in which new technology are incorporated and new media, lots of content that has been acquired perhaps in older formats and want to make available in newer formats, newer media, things start falling apart pretty rapidly. And even more so if you get to a virtual classroom like this, a virtual teaching space, so distance education and MOOCs. Lots of creative thinking needs to be done to accommodate the current framework of the Copyright Act, to accommodate these kinds of virtual classrooms. But I'll talk about that. Despite the title, you might think, well, I'm just going to jump right into fair use, or possibly even the TEACH Act. But before I even get there, what I want to propose to do is think about a framework for trying to think through these things in a coherent way, according to the structure of the Copyright Act, according to the logic of copyright and what it actually protects. So before you even get to the kinds of question, is this fair use? There are all kinds of preliminary questions that you really want to ask yourself. And the first one is it even in copyright? Is it copyrightable? Is it the stuff of copyright? Is copyright even implicated in this thing that I want to use? And it could be something that's a part of a copyrighted work, and as we've seen in the last, just a week ago in the Google Books case, what that case makes really clear, and other cases make really clear, recent cases involving the digitization of copyrighted works, is that just because a work is copyrighted, it doesn't mean that every element of it, every bit of it, all the stuff in it is copyrightable. So there's lots of stuff in copyrighted works that isn't copyrightable, for which you don't even have to get to the fair use question. So that's the first level of analysis, and that's where I want to start. So the first question is, under Section 102 of the Copyright Act, if you want to follow along with your copy of the Copyright Act, is just this test of copyrightability, of what does copyright protect. And what it protects is original works of authorship and a fixed tangible medium of expression. And as my student Erica can tell you, we spent 3 hours on that, and I'm going to propose to unpack this in 3 minutes. There are essentially 3 parts to this, 3 basic parts to this. Originality, fixation, and expression. So if something is copyrightable, it's got to be an original work of authorship in a fixed tangible medium, and it's got to be an expression. So what copyright protects are expressions. Let me unpack that. So the first part is just originality. It's got to be somewhat original, and the threshold for that is very low. But it's got to involve, in the words of some judicial opinions, an intellectual contribution of the creator. And that's very low level. It doesn't take much, And that's all I'll say about that. But a little bit of originality is required. Next thing, it's got to be fixed. It's got to be a tangible medium. And that's actually really a policy question, a policy choice that copyright makes. There are some state laws that protect unfixed expressions of ideas. But in federal copyright law, there's a policy choice made there that says it's got to be fixed. Because what judges don't want is arguments about who had some idea first. They want to see the thing fixed. They want evidence of when it was fixed and so on. And more importantly, under federal copyright, what is protected is expressions. So the actual expression of the idea, the words chosen, the construction of an image, the creation of a work of art, not ideas, all right? But the expression. And then infringement, or alleged infringement, becomes an examination of the extent to which an infringing work is substantially similar to that original copyrighted expression. So only original works of authorship in a fixed tangible medium of expression are protected. So a lot of what we use isn't implicated by copyright. A lot of the stuff that is the stuff of classroom teaching is potentially not even in copyright. So, and my sense of, kind of the popular mood about copyright is there's a lot of anxiety about it that tends to shut down this kind of analysis and this kind of questioning, just kind of paralyze people as they're trying to use things. So first level, is it in copyright according to that standard? And this expression requirement actually in case law has led to a distinction in the cases, or in case law, that gets referred to as the idea-expression dichotomy or the fact-expression dichotomy. Okay, so again, what is protected by copyright are the expressions, not the idea, just the way the idea gets expressed by the creator precisely in its published form or its created form. So there's a way in which we can talk about ideas, other people's ideas, we can put them in our own words, we can relay them in the classroom, and so on, we can exchange them. And that is precisely because of the constitutional imperatives of copyright. So in the Copyright Clause, which is Article 1, Section 8, Clause 8 of the Copyright Act, the goal there, it gives power to Congress to regulate in this area, to create legislation in the area of copyright and to, sort of embody, create a zone in which that is rewarded. So the goal in that Copyright Clause, or one of the rationales for this, is that we give creators and authors a monopoly on their creative expressions for a limited period of time, which has become practically unlimited. I mean, there's things created today that will be in copyright for decades after I'm gone and everyone in this room is gone. So that starts looking like perpetual copyright, but it's still technically limited. But the goal there, again, is to reward creators for their expressions, but to leave ideas free for public exchange, public consumption, so that other people can take up an idea and express it in their own way. So what we don't want is to give people a monopoly on ideas. And we don't want copyright to be the basis for censorship, for example, which a lot of people do. A recent case, a wealthy man in Florida bought an unattractive photo of himself because a critic of him was using it in blog posts. And it was an unattractive picture. And he bought it so that no one could use it. Copyright isn't meant to be a form of censorship. So the woman who was blogging about him quite critically won action in federal court on appeal. And the court made precisely the observation that copyright's not for censorship. And they also said that, and this is important, the photograph was largely informational. It wasn't a fine art photograph. It was just a photograph that happened to be taken of him at a basketball game in which he's sticking his tongue out the side of his mouth and just looks generally unappealing. And it turns out he has a generally unappealing personality and character, and that was the object of the criticism. So that was a fair use, but the judge, in deciding the case, also made the point that this photograph wasn't entitled to a whole lot of copyright protection because it was simply informational. So I cite that case just to draw out this distinction, that facts not protected, expressions are. And there's ways in which a copyrightable work could be eligible for or enjoy less protection because it's more fact-based rather than creative, or the object of creative imagination and work, all right? So, once you've met this standard, the Copyright Act establishes a list of examples, exemplary kinds of things that are protected. So literary works, the kinds of things you would expect, but also much more broadly, advertising, copy, software programming, language is protected by copyright and so on. Musical works, including any accompanying lyrics and words, dramatic works or plays, but also any accompanying music, pantomimes and choreographic works to the extent that they're fixed in some tangible medium expressions, either through choreographic notation or videotaped. It just has to be a fixation of some kind in some medium, all right? Photography, graphic art, sculpture, fine art, things you'd expect. Motion pictures and other audiovisual works, architectural works as of 1990, so I'll say more about the public domain, but architectural works not protected by copyright before 1990, at least in the United States. So that's a whole body of work potentially available in architecture and art history classes and so on, or as derivative works that people might create from them and so on. And then sound recordings as of 1972. And so sound recordings are really interesting in a lot of ways. They didn't enjoy federal copyright protection. And this actually created a lot of problems. And there's a movement afoot, might actually succeed to bring these pre-72 sound recordings under federal copyright protection in order to harmonize. Right now they're protected by state copyright laws in a sort of ad hoc fashion across the state, inconsistent way across the state. So the goal is to bring them under federal copyright protection so we've got a consistent way of dealing with them for preservation projects and other kinds of things. And finally, compilations and derivative works. So works derived from other works and compilations of works in copyright. That compilation, the idea of bringing things together under a certain theme or under a rubric or in a certain order and arrangement, that idea, as expressed in this compilation, is also copyrightable, even though the underlying works have their own copyright status, all right? So that's all under Section 106. So this brings me to what, again, to just reaffirm what copyright does not protect. So I haven't even talked about fair use yet, and it's going to be a while till I get there. So a whole lot of analysis, a whole lot of thinking, before you ever have to even worry about copyright, even though we spend a lot of time anxiously worrying about copyright. So copyright does not protect ideas. I hope I've made that pretty clear by now. It doesn't protect facts or information. And by extension then, and so this is where I want to bring this, the point I want to get to with all of this. So the kinds of things that are the stuff of teaching that you want to make available in distance education or MOOCs or whatever, potentially not copyrightable. So an easily reproducible chart, table or graph. So something in which information is organized in a kind of obvious way, alphabetically, chronologically, temporally. Those are obvious ways of organizing information. The information's not protected, and the way in which it's arranged is obvious to human cognition today, the way we think and organize stuff. So that's a chart from a journal article, let's say, for example, of minority representation in the French National Assembly from former colonies. So someone goes to all the trouble and effort of finding out who all the representatives in the French National Assembly who are either from former French colonies or descended from people who came from French colonies, organized with much effort and research. But that is just information. The idea of that could be replicated by someone doing the same amount of work. So the Supreme Court has famously held that sweat of the brow arguments, work, putting lots of work into something is not protected. So again, the kinds of stuff that we might want to use in distance education, on a MOOC, so on, a scientific table, mathematical principles, formulas, algorithms, information organized in a certain way, even if with a lot of effort, not copyrightable, all right? What's copyrighted are original works of authorship in a fixed tangible medium expression. You've got to get to that threshold before copyright is implicated. So what I want to suggest is, what is the thing you want to do? Analyze it from this perspective. Do you need to worry about, is copyright even implicated? I hope that's somewhat clear at this point. Other things not protected by copyright: names, titles, slogans, short phrases, or common expressions. Big problem in the music industry now is that a lot of music is formulaic. A lot of lyrics are trite and cliched. So I forget the woman's name, but the song is, if your lips are moving, I know you're lying. I mean, the first time I heard that song, I thought, one, it sucks, and two, wow, none of that is copyrightable. None of those lyrics is copyrightable because the whole song is nothing but cliched expressions. Not, again, just to illustrate this point, not original works of authorship in a fixed tangible medium expression. So it could very well be that you want to talk about insipid pop music. I don't know if that would be the subject of a class lecture, but those lyrics by themselves, not copyrightable. There are lots of songs called I Know You're Lying If Your Lips Are Moving, or some variation on that. So, again, I'm just trying to make this point in different ways. So before you ever start worrying about copyright, start asking these questions. Finally, government works, a really rich repository corpus of things not protected by copyright, not because they're otherwise not copyrightable, but because federal copyright law exempts them from copyright protection. So rich corpus of information and scholarly resources that anyone can use freely, all right? So first level, is it even in copyright? Do we need to worry about copyright at all? Is copyright implicated? That's the first level of analysis before you move any further, all right? Next thing is it in if it was in copyright, is it no longer in copyright? So copyright in the United States and under the copyright laws of nations that are members of the Berne Convention, all have copyright for a limited time. So creators enjoy a monopoly on creative works for a certain period of time as an incentive to create works and to reward or incentivize the investment in publishing those works. But after a while, a very long while at this point, but shorter whiles in the past, and I'll say more about that in a minute, things enter the public domain, and then no one owns them. And I can't tell you how many times I hear from graduate students and faculty, I want to do such and such with this image from an 1894 Victorian novel. And I say, you can turn it into posters, t-shirts, you can put it on billboards, you can do whatever you please. And so this public domain, I think people hear the term, I think they understand what it means, but in my experience, they don't fully appreciate the significance of that. No one owns it any longer. You can do anything you want with it, all right? So, and the other thing, the other kind of popular misconception I want to just kind of address to this group, as you head back out to your jobs, is that I think everyone knows in this room knows and must know and appreciate that things first published in the United States before 1923 are in the public domain. But because of technical requirements under US law, under the 1909 Act, which was the act before the current 1976 Act, which should give you a sense of how long we'll be waiting for the next great Copyright Act, as the current Register of Copyrights likes to refer to it. I expect to be retired, and I'm middle-aged, but I'm not. I still have a ways to go. But anyway, under the 1909 Act, there were very specific technical requirements for copyright protection. So something first had to be published with a copyright notice on it, the C in the circle, classic copyright symbol, in order to be in copyright. And if you didn't do that, if you made that mistake, there were ways of correcting it, but they were limited. And if you didn't, it was automatically in the public domain. And this was an easy mistake to make. There are lots of films from the 1960s that are in the public domain, and despite all the effort that goes into making a film, someone didn't put a C in the circle on the front, the opening credits, which means those films are in the public domain now. So there's a whole body of work. And then the other requirement is that you had to renew the copyright after 28 years. And that requires some technical research, as my student in the room will tell you, that is fallible, right? Because you're looking for something that doesn't exist. You're looking for a renewal notice, and when you don't find it in the really crappy resources we have for doing this research, you think, okay, it's in the public domain, and you're looking, so there's the potential for a lot of false negatives in doing that research. But it's something to be aware of. There's a whole body of work under the law, first published in the United States between 1923 and 1963, that if it failed to meet these technical requirements of including a copyright notice and renewing the copyright, it's in the public domain. So that's a whole body of work. One great resource for finding that work reliably is the Hathi Trust. So a really rigorous program of reviewing works under US copyright that's in the US part of the database. That's research that's conducted by a group at the University of Michigan called the CRMS, or Copyright Review Management Service. Rigorous protocols for clearing that stuff. So if you go to the Hathi Trust and find something open, that is reliably in the public domain, and you're free to do whatever you please with it, all right? So another body of work, and there are other places as well, less reliable in some cases, but generally, reliable. what else do I want to say about that? Oh, one just note, this occurs to me, is the problem of orphan work. So we've got, with these longer copyright terms, we've got a lot of works for which rights holders are no longer available. And I think if your institution has a pretty coherent policy for what constitutes an orphan work and a set of protocols for different kinds of works, to try to make some sort of reliable determination about if something's orphaned, I think then on the basis of some sort of risk assessment, you could start using those works as well in certain ways to the extent that your institution feels comfortable with that. But the public domain, clearly available for whatever you want. So it's something else to think about. If something's in copyright, so once you get to, if something's in copyright, it comes with a bundle of rights. And it's also important to be really clear about just what those rights are. They are no more, copyright is a statutory right. In some countries, it's considered a natural law right, and creators have what are called moral rights. But in the United States, it's a statutory right, and you have only the rights that the statute says you have, no more, no less. So if you want to do something that exceeds these rights, and I'll try to illustrate that a bit, you're free to do that, because they only have the rights that the law says. First right, first and foremost, copyright is fundamentally about making copies, to make copies or recordings of the work. But if you're not making a copy, if the way in which you deploy something doesn't involve making a copy, there are other rights here as well. But here's the example I want to use. So the technology creates problems. It also has created solutions. So for example, if you're simply hypertext linking or embedding a copyrighted work that is being performed publicly from another website, you don't have a license and you're not sure if your use is a fair use, that doesn't involve copyright at all. So you can embed that in a course website. You could even embed it in a MOOC. You could use it in distance education because you're not making a copy. If you're not making a copy, it ain't copyrighted. I mean, it's copyright, but copyright protections on that work are not implicated, right? It's streaming, it's being performed from another website that happens to be embedded in yours, or the image is embedded, or you're linking to something else. You're pointing students to where the resource is available somewhere else. So if you're not making a copy, you can use the technology to, in these ways to get around the problems of copyright. So that's an important, I don't know if you want to call it a trick, but just a strategy for dealing with things, copyrighted works in these kinds of new teaching spaces. Now, the second right is distribute copies or recordings. So beyond the first sale, after the first sale, you can do what you want. There's a lot of things, but that right of first distribution is owned by the rights holder. And how things get distributed, including digitally, is within the purview of the rights holder. To prepare derivative works, so to create new works from an original work, to perform the copyrighted work publicly, and to display the copyrighted work publicly. So again, public, you can perform things privately. And what counts as public performance and public display are hotly debated. But a good one, there are 4 rules in the Copyright Act, one of which says if you simply transmit something publicly and no one hears it, that is a public performance. So if you have a recording of a tree and you broadcast in the woods and no one's there to hear it, that's a public performance, all right? But the rule, I think, for what we do, that's the definition that is most used for what we do, and you can find these definitions in Section 101 of the Copyright Act. A public performance is one, defined in Section 101, is something outside a circle of acquaintances or friends, all right? So that's a good practical guide. So the classroom is not a circle of acquaintances and friends, or family and friends. It's broader than that. But then it becomes debatable after that. So it's a group of, if it's a group of students who want to watch a video in the library and they check it out and go into a classroom and bring some other people along, is that a public performance? Or if the library wants to advertise a film and show it, is that a public performance? More likely. Anyway, it's a debatable rule, but you should treat most of what we do as a public performance. And then certainly stuff on websites and things like that will be a public display, all right? So I haven't gotten to fair use yet, but I'm about to. So in the Copyright Act, so you've gotten to the point where you establish whether or not something's in copyright, either because it's copyrightable or it's still in copyright under the length of terms of copyright. If that's the case, then your use of that thing under copyright law either has to be licensed or it has to fall within one of the limitations on exclusive rights found in the Copyright Act from sections 107 to 122. So 107 is fair use. I'm still not ready to talk about that yet, all right? Still things you want to think about first before you get to fair use. And if your use of it is licensed, then the terms of the license are going to be dispositive of how you use that thing. No longer copyright. Now you're in the realm of contract and outside of copyright, all right? So we can talk about license if you want, but I'm going to move forward with copyright. So again, under sections 107 to 122, there's this whole litany of limitations on rights holders. So statutory limitations, they say, regardless of the fact that you, rights holders, own this thing, Congress says you have to allow for these certain kinds of things. So 107 is fair use, and I'll say more about that later. 108, for example, covers all the kinds of reproductions and copying and distribution of copies of copyrighted works that libraries can engage in. Section 109 is for sale. It says that after you've bought something legally the first time, you can dispose of it however you wish, including sell it. Section 115 says that something, a non-dramatic work of music has already been recorded, you can make a recording of it yourself, so long as you pay the mechanical licensing for that. And then just jumping forward, section 121, which is a big deal in the Google Books and HathiTrust cases, says that you can make copies and digitize things and make copyrighted works available in a way that are accessible to print impaired people or the blind. You don't need a license for that. The thing I want to talk about, though, a lot in connection with classroom use is section 110. So before, still not fair use, still not section 107. Think about 110 first. So 110.1, there are actually many sections in 110. I want to talk about 3 of them. The first one is classroom performances and displays. So this is a limitation for 2 of those exclusive rights, public performance and public display. And what section 110.1 allows for is the performance or display of a work by instructors or pupils in the course of face-to-face teaching activities in a classroom, face-to-face, live. It has to be at a non-profit educational institution. You have to have a legal copy of the particular work, and the work has to be somewhat relevant to class instruction, all right? What's great about 110.1 is that there's no limitation on the kind of work. It just says a work. So this is a very large umbrella for all the kinds of things you want to do in a classroom, including showing movies, showing television advertising, performing musical works, whether dramatic or non-dramatic, and some of the other sections actually specify only non-dramatic works. So basically, have at it. Do whatever you want. In a regular classroom, you can perform, display, show whatever you want in the course of face-to-face classroom discussion. There's nothing here about making copies, nothing here about distributing those copies, so those are separate considerations. You want to provide copies to students. But in terms of performance and display, carte blanche, do what you want. You're free to do it, all right? Section 110.2, the Teach Act. So what 110.2 tried to do in 2000, or what Congress tried to do in 2002 with the Teach Act, was to some extent extend the provisions, and I say to some limited extent, extend the provisions of 110.1 to distance education. And it comes with a whole lot of requirements that are hard to meet, but minimally, what you've got here is an expression of congressional intent that distance education is important, the technologies that support it are important, and that Congress meant to foster those in some way. So 10 years out, over 10 years out now, there's a sense in which the Teach Act has not been a big success, but it gave us that much, that expression of congressional intent. The hard parts here are, so first off, there are a whole lot of requirements. The copy must be made by or at the direction of or under the supervision of the instructor. It has to be directly related, so not just somewhat related, but directly related and of material assistance to the teaching content. So no gratuitous uses of cartoons and films to while away the hours. You've got to have a pretty clear pedagogical purpose for using this stuff. And the transmission has to be limited to students enrolled in the class at a not-for-profit educational institution. If those are conditions are met, then the material copy is limited to, in a way that 110.1 is not, the performance of non-dramatic literary or musical works, such as reading a short story or listening to a piece of music. So dramatic works are excluded by this, for starters. It also have to use reasonable and limited portions of any other work. So the broad grant of a license is for non-dramatic literary and musical works. For other things, you've got to use reasonable and limited portions of any work. The Congressional Research Service issued a study about the Teach Act and said that reasonable and limited could actually include the whole work. I think that's a risky assessment of things, but the idea is something like this. If you're offering a course on the films of Pasolini or Italian neorealism, and you need to watch the films of Pasolini, it could be that, reasonable, you have good reason to show the entire work, but you've got to be able to show reasons. And I don't know how that accounts for the requirement that it be limited, but the Congressional Research Service has said that's possible, and some people have defended that view. I do not. So I would just say proceed at your own risk if you're going to post something like a film on a distance education website. Another problem, well, let me keep moving. Other things excluded are, it does, and it goes on to say, and here's something else why I think you got to stick to the limited language of limited portions. Display of a work in an amount comparable to that which is typically displayed in the course of a live classroom session. So you can't just load up a distance education course with a lot of films or other audiovisual materials that students would watch on their own time. The content that you make available on a distance education site has to be fairly comparable to what you would be able to cover in class in the course of face-to-face classroom instruction, right? So if you could watch a whole movie in the class time that's allotted, then fine. But if you could, if you can't watch 2 or 3, then you can't go that far. Finally, the works have to be primarily, you can't include works that are primarily produced for distance education. So those are going to be covered by the licenses for those products. You can't use something that's an illegal copy or that the instructor should know is an illegal copy. And you can't use textbooks, course packs, or other material typically purchased by students. There are also a lot of technological requirements that are hard or inconvenient to meet. So one of them, for example, is that you can't make this stuff perpetually available. It's got to come down when the class isn't being taught. And really, the sense was that the stuff had to be removed from the servers, or the copies had to be removed, and that's just kind of inconvenient. If you create a distance education class, you want it to be available and flip it on, flip the on switch later and have it be. So that's a tough thing to meet, or at least an inconvenient thing to meet. So for all of these reasons, lots of people rely on fair use. One other requirement is that you can't bypass anti-circumvention measures under, so software that's meant to prevent piracy or copying of these works that was prohibited under the Digital Millennium Copyright Act. So that's a big problem for films and audiovisual materials. I think there are ways around this. One of them includes the regulations of the Librarian of Congress, which are the regulations of the Copyright Office, which does allow you to do this if you want to show short excerpts, excerpts or short scenes in classes related to film studies or in which film or audio-visual materials have to be used. So that's a big problem. I think another way around this, you can do this, I would say, but I think you want to seek the advice of your own counsel for works that aren't protected by anti-circumvention software and aren't available in a digital copy at a reasonable price. So if you've got something on videotape that's no longer in print, I think it's safe to digitize that and make it available in digital form and streaming form on a distance education website or on a course management website, for example. But bypassing that anti-circumvention software is a problem. So that's the Teach Act. With all of its faults, again, one big takeaway is that it at least expresses the Congress's intent that distance education is important. And that actually helps with fair use, which is, I think, where lots of people end up in distance education, making stuff available on distance education platforms. 110.4 actually covers nonprofit performances, and this is actually a great use to libraries. It covers all kinds of things. Anytime you want to perform publicly a work for not-for-profit purposes. So, and it could even be a fundraiser. You could charge for that performance so long as none of the participants are getting paid. and all of the money after costs is going back into the programs or services of the group that's holding the fundraiser. The only limitation on this is that a rights holder can send a notice in writing within 7 days of that performance objecting to it. But what this actually makes possible for libraries, and I actually call this the story time and fundraiser section, because that's precisely what it does for libraries. Among the things that you can perform under 110.4 are non-dramatic literary works. Well, non-dramatic literary works are children's stories for practical purposes in libraries. So you might not think about it, or you might take for granted that you're allowed to do that. That public performance of that work, that story, is actually one of the rights of the rights holder. And 110.4 says, just to be clear, it's okay to do that. But again, that's because copyright gives people these statutory rights, you need these limitations just to sort of upend that or bracket those rights. I am now ready to talk about fair use, and particularly in the context of the 21st century classroom, because I think that's where it's most significantly implicated, and where we really need to think creatively, because the law has not caught up to the technology. So all we've got is fair use. So what Section 107 does is, and courts have, and I think one way of thinking about this is, in the terms of the Supreme Court, they called it a constitutional or First Amendment safety clause. So yeah, copyright grants a monopoly to rights holders, but we still want to preserve this kind of free exchange of ideas that the First Amendment privileges. So fair use is very much, when it was codified in Section 107, it had been based on a century of case law from the Supreme Court and other federal courts. It was codified in Section 107 for many reasons. One, to codify that case law, but also to have a kind of First Amendment safety valve built into the Copyright Act to say certain things are still going to be possible. And certain things are privileged explicitly in the preamble to Section 107, namely purposes such as, so these are exemplary, it's not limited to these things, but these things are privileged. Purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship or research. So, a lot of what we do is treated with special favor under Section 107. So that makes the thinking about fair use in this context easier, I would say, than some other kinds of uses. But your use still is still subject to 4 factors included in Section 107, and they are as follows: the purpose and character of use. So this section asks, what are you doing here? What are you doing? What are you trying to do? What's the purpose and character, including whether or not your use is educational, non-for-profit, or commercial. And there was a way in the case law in which educational fair use was very much privileged and is privileged. And then it asks, what's the nature of the copyrighted work? And this actually gets to the point I was making earlier about copyrightability. So what is the nature of this work? Is it highly creative poem or fictional work or literary work? Or is it a work of nonfiction, a scientific journal article that describes the methodology for conducting a certain experiment, in which the expression is very much tied to just the steps, the informational steps that you need to take to replicate this? If that's the case, there's much less copyright protection for something like that. And we saw this very clearly in the Georgia State case, which I'll talk about a little bit. So, is it the work of fiction or nonfiction? Is it published or unpublished? The former of those two dichotomies, more privileged, the latter less favored. Finally, the amount and substantiality of the portion used in relation to the whole. So how much and how important was the part that you used? Is one of the questions, and then the effect on the potential market. So the way this, the way this looks is flexible, and it's unclear, and even judges can't agree on it. So, for example, in the Georgia State case, 3-judge panel, 2 decided in favor of Georgia State's use in making stuff available electronically on an e-reserve system, articles available on an e-reserve system, and 1 judge said, this ain't a fair use. So if federal judges can't agree, or as is the case between the 2nd Circuit and the 7th Circuit, they don't like, 7th Circuit doesn't like the idea of transformativeness and has been really critical of it. So if federal judges with decades of experience can't agree about this, it's reasonable for us not to be able to agree about it or have a clear sense of how to apply this stuff. But that's the basic framework. In the absence of that clarity, there are lots of other resources that you can look at. So there are fair use checklists online. One was developed at IUPUI by Kenny Cruz and Wayne Butler. That's a useful resource. You can get it on many websites, copyright websites around the country. There are also increasingly these codes of best practices for fair use. And in this context, I want to reference one in particular, the AR Code of Best Practices for Academic and Research Libraries. Principle 1, it is fair use to make appropriately tailored course-related content available to enrolled students via digital networks. All right? So this actually came out before Georgia State, and Georgia State has given a lot of cover for this claim. But yeah, the technology is there. Students expect it. It's how we do business. Even if you want, and as they argued, as the plaintiffs argued in the Georgia State case, this is for commercial advantage. You know, colleges and universities are in the business of education, and this makes them more marketable in that, you know, very lucrative marketplace. So anyway, one thing, you know, this came out and said, everyone surveyed, lots of people surveyed, there's a clear consensus about this, and it's articulated under this first principle. So there's some cover there for, you know, course management systems, distance education. I would say not MOOCs, because it's not, you don't have enrolled students, and it, you know, so anyway, for at least the two things that we do within our institution, that's possible. I actually want to talk about fair use in the light of this one case that was decided recently. So it's Cambridge, Oxford, and Sage Presses versus Patton is actually the name of the case, but it was Georgia State University. And what it made clear, or what this case makes clear at this point, is that you can make digital copies of texts, non-fiction articles from monographs, scholarly monographs, available on course management systems. And this was the analysis. It also included funding from the Association of American Publishers and the Copyright Clearance Center, which should make you cautious about who your friends are. Copyright Clearance Center is probably not our friend. And it's useful to know what their goal was here. What they really wanted was to sell their blanket license for making stuff available through course management systems. And the 11th Circuit rejected that claim. And what they did was apply these 4 factors. This is how it works. So same thing federal judges do is what we need to do in the context of our work. So the first thing they looked at was first factor, so the purpose and character of the use. One thing they noted was that it's not transformative. And I'll say more about what transformativeness is, but it's become a really powerful concept for thinking about fair use and the first factor in fair use. And it looks at things that provide new uses, new aesthetics, and so on. But they said this isn't transformative. This is just plain copying, plain and simple. You're making copies and you're putting on a course management system. But they said it was for a highly favored educational purpose. So this is really significant, actually. Don't need to be transformative. You can just make copies of complete articles that are a part of scholarly monograph and put on a course management system. That's okay. So that's one really important takeaway from Georgia State. Another factor, in the trial court, the judge said that when they looked at the character of the copyrighted works, the trial court judge said these are all informational works and less eligible for copyright protection. 11th Circuit rejected that claim. So you still got to go through the thinking that I described at the beginning. What is the nature of the work? What is the relationship of the expression to the informational content in the articles? How integral is that expression to the information or facts that are being relayed? If you're simply describing facts, historical events in chronological order, that's more factual than expressive. But you can't just dismiss all nonfiction works as informational. That was a big, important point made by the 11th Circuit. Third factor, you can't have bright line rules, which is kind of unfortunate. One of my colleagues at the University of Minnesota, after this case came out, said this case helps no teacher anywhere. No teacher will be able to figure this case, can apply this rule. The trial court had given us a really clear rule. It was basically 10% or one chapter rule, depending on the length of the book. And for a year, my job was really easy. Well, all we had was that case. I'd say, oh, there's this great case, and it says this. And everyone left my office or joyfully responded to my emails. Now I've got to work. You got to work through each thing you want to use on the basis of these 4 factors. It's a problem. The other thing they said here was the course pack cases are not fully or binding authority. That those were commercial. So like the Kinko's cases, or your campus document copy center that is creating course packets, they argued that was separate. The one judge who dissented disagreed and said, this is just like that, I don't see the difference. But 2 judges said it was. So we've got this case. Finally, the 4th factor looked at the market impact. And this is on the potential market for this thing, or for your use. So, the standard they adopted was substantial harm. And that's a pretty tough standard to show, actually. And when they looked at the data for licensing for this kind of use, for course management systems, they found it was less than 1% of the revenue for those companies. And they said, well, you're not doing anything here, you're not making much here, and if everyone did this, it's not going to cost you much. The standard here is substantial harm, which is pretty hard to show. Just to say a little bit about transformativeness now. Again, it's been a really powerful concept in the Google Books decision, the How Do You Trust decisions. It was decisive. So there you've got cases in which you can copy 20 million books completely, put them on a database, but your use is completely transformative, in the words of the court. The argument there is that authors do not write books to put them on database and make them subject to full text searching for the frequency of search terms or just more information about the book. And what Pierre Laval, the judge in the Second Circuit Google Books decision last Friday said, and who gave us the notion of transformativeness in a law review article in 1990, said, what all that Google Books is doing is providing, and this is really key, information about the books. And information is not copyrightable, okay? And even in that case, used the example of someone using Google Books as a reference source. So he used the example of a student writing a paper about and wanting to know when Franklin Delano Roosevelt contracted polio. That's what they needed to know. And they did a search. You can do a search and find out that he contracted polio in, 1938 or something like that. I forget the exact date. And he said, so what? That's okay, because all they got out of the book was information, and information is not copyrightable. So one more attempt to kind of illustrate the significance about the idea, fact, expression dichotomy, okay? So, but the way Laval described transformativeness in his 1990 article was taking original copyrighted material and using it as raw material, and possibly transforming it in the creation of new information, Google Books, How Do You Trust, new aesthetics, and there are some important cases dealing with art and artistic images, new insights and new understandings. So what I want to argue, these are not my arguments actually, there's a guy named, these are arguments advanced by a gentleman named Brandon Butler, who was actually the principal investigator for the ARL Code of Best Practices. He was with ARL, he's now at American University. And in a recent article, and I want to close by, he argued, and I want to close with this suggestion that we should think more about transformativeness in teaching and the way in which what teachers do is actually transformative, and also the way in which we make materials available to students electronically with new technologies is transformative. So here's some of his arguments. One is that we use current media or expressive works to teach critical thinking and analysis and problem solving. So one example might be you use images from the film Aladdin, or news representations of Muslims to talk about the issue of representation of religious minorities in US culture and society. That is not consuming the news article, and that is not consuming, or the news story from television, and that is not consuming the film Aladdin the way in which it was intended to be consumed, as entertainment. That is a new transformative use. You're critically bracketing the work and subjecting it to the scrutiny of students in your classes or perhaps online and distance education. Teaching history through primary sources or archival materials, so taking copyrighted newspapers, historical texts, historical films, and analyzing them, criticizing them, examining them in a class. That is transformative. Teaching lectures with third-party media, another really, I'll skip over that one. Another really important thing, lots of students want to create new digital works with existing works. They want to use recordings and as soundtracks in new films, or they're making, journalism students, IU for example, make a lot of sort of news stories, audiovisual works that are news stories, and they want to have film in the background. I think for purposes of doing that sort of thing, or for teaching software, or for creative purposes, it's okay to do that. I think that's a transformative fair use. The problem is going to be that students want to use those works in other ways, in portfolios, or put them on pre-professional websites and stuff, and that's a separate use. So each use has to be analyzed separately. Your use in classroom is going to be separate from other things you might want to do. I think another shortcoming here is that it's actually useful for the instructor in those kinds of classes to guide students through the kinds of analysis I've suggested today, in which you want to think about are there things that aren't protected by copyright, or they're in the public domain that you could be using, and that students could then create works from that they could use and advance professionally. So, it's an idea here. Yeah, you can use this stuff for teaching purposes, but I think there are other things you can be teaching them along the way that are significant here. And finally, just assembling galleries and playlists, creating images of works, curating those collections of digital objects on course management systems and distance education websites and so on, that is transformative, that puts a critical spin on things that are intended by the instructor to create certain critical insights. So these are the kinds of arguments that Butler has advanced. I think they're great, and I think we should be thinking about them. And I think a way of advancing these arguments, and I recommend this to people generally, when you're relying on fair use, don't just, in a shorthand way say, oh, fair use, I'm just going to go ahead with this. If something's really on the margins and you're not really sure about it, document it. Write yourself a memo, write yourself an email, just walk through those 4 factors and document why you did this thing, because there's a lot of protection, particularly for librarians under section 5042C. There's a statutory limitation on liability for librarians. If you've relied on something as a fair use in good faith, then you're not liable for statutory damages or attorney's fees. You're only liable for actual damages, which can still be somewhat significant. But for an orphan work, it could be nothing. And for a lot of commercial works, or a lot of works that have limited commercial value, not much money is involved. But a good indicator of fair use is actually having documented your thought about why you think that's fair use in terms of those 4 factors, and then just drop it in a file somewhere. So that's all I've got. This is one of my chickens, Allison, my favorite chicken, and I wanted to bring her along too. We're going to, I think, so Craig wanted to invite up the 2 presenters from Notre Dame, and to the extent that some of us are still standing today, have a collective Q&A. So any questions?
Yeah, hi, Dennis.
Hey.
What did you think about the textbook ruling by the Supreme Court regarding copyright gentleman that was overseas?
Oh yeah, so that actually involves first sale. So it's Kirtang. Yeah, so that's the Kirtang case. I think it's the right decision. So just to let everyone else know, the case about Kirtang was a graduate student at Cornell who was from Thailand or Nepal, yeah. Maybe Nepal. Tibet. But anyway, some Asian country, and he noticed that textbooks in the United States were being sold at dramatically greater, significantly higher costs than they were in his home country. So he asked his family to start buying out textbooks in his native country and sending them to the U.S. And this was an enterprising gentleman. His revenues were $1 million. So the publishers went after him and basically upheld. The argument of the publishers was that the first sale rule, section 109, so another limitation under that series of limitations from 107 to 122, they basically, what the publishers argued was the first sale rule only applies to works first published in the United States. And they said, no, that couldn't be the case. And actually lots of people came in to appreciate the significance of copyright. One of the amicus briefs was filed by automobile manufacturers, because there's lots of software in cars. And if the first sale rule didn't apply to a car with the software in it, you'd have lots of problems reselling cars when they're manufactured abroad, shipped to the United States and sold here. So anyway, I think Ruth Bader Ginsburg wrote that. I think she wrote that decision. Anyway, basically rejecting that argument and saying it applies to works first published lawfully, however they're published lawfully under the laws of the country in which they're published. So when a company publishes something abroad and sells it in that market, that's a valid sale. The only requirement is it's a valid sale. So librarians love that case. I mean, the publishers hated it. And I don't know how they're responding to it in those foreign markets, but I guess I'm assuming there's been a response of some sort. So.
Thank you.
Yeah. Yeah.
In the Google Books case, there was one line that I noticed worried a few people
okay.
About it seemed to kind of disfavor educational materials created specifically for education a little bit. Something like, found one of the tweets anyway, that just because that education isn't as strong a cover if the work was created for educational purposes. And I was wondering what you thought about that. If that's going to have an impact on fair use in higher education.
I think that, I mean, I have the opinion here, and I've read it a number of times now. I mean, I think maybe they said something the obverse of that actually a little bit. I mean, the focus was on whether or not it was commercial. So what the Authors Guild argued was that Google was, that this wasn't an educational use, it was actually commercial, but their interests are commercial. Are you still, if you find it, let me know. But
yeah, it's the...
What does it say?
Let's see, just as there is no reason for presuming that a commercial use is not a fair use, there is likewise no reason to presume categorically that a nonprofit educational use should qualify as a fair use. And then it talks about authors who write for educational purposes and publishers who invest substantial funds to publish educational materials.
Yeah, I mean, I think the point of the case, and it's brilliantly written, and when it does something that none of the other most other fair use cases don't do. So the four factors really need to be thought together, and I think the point of that statement is that you can't just dispose of, and I think maybe this is what they're responding to. So in fair use cases, historically, courts would look at the first factor and say, is this educational, not-for-profit, or is this commercial? If it's commercial, ding, you're done. And if it's educational, not-for-profit, then they'll maybe work through the rest of the four factors. So I think that's the point of that claim, that you've got to think these four factors together, and Laval does a brilliant job of thinking them together. Most other courts, when you read the decisions, and the earlier Google Book trial court decision, they kind of treat it like a math problem. First factor, second factor, and then tally up the score and decide the winner. And this is a much more flexible rule. It was never meant to be a math problem, but it's turned into that a little bit. We've got a different problem now with transformativeness, and that's kind of, if they decide it's transformative, then that's kind of outweighing things. And in the Google Books decision, Laval responds in a very long footnote with a bit of snark to the Seventh Circuit, which we live and work, which has been critical of the notion of transformativeness, because in the Seventh Circuit, they argued in a case this past summer that, it involved a case, using art images, but basically, some artist, basic guy makes tens of millions of dollars a year as an artist, ripped off some images from a guy who does fine art documentary photographs and lives among Rastafarians in Jamaica and subsists. And the Seventh Circuit looked at the Second Circuit and said, that completely supplants the derivative right, or the right to create derivative works. Because under the first factor, if you say it's transformative, suddenly how do you make sense of it? So I think what Laval, and I don't remember reading that precise statement, but Laval is very keenly interested in making clear that nothing is dispositive of the first factor. Not transformativeness, not commercial use, not educational use, nothing is dispositive of fair use, or the first factor is not dispositive of fair use. You just note what it is, and then you think through the other factors, all right? But that's been a problem all along. So I think that's maybe the point of that. I'll have to go back and look at that, but I think that's where it's going. Anyone else? Okay.
Actually, I was going to ask you about the art case.
Okay.
Because it really bothered me.
Oh yeah, you're not alone. Okay, so this is a case. I love this case. This is a case called Patrick Carreau versus Richard Prince. So Patrick Carreau is a fine art documentary photographer who lived in Jamaica for many years among Rastafarians in a very respectful way, very much part of the community, and took exquisitely beautiful photographs that were published in a coffee table book, an art book. And Richard Prince was in Jamaica, picked up a copy, at least that's the story I've heard, and took them back to New York and turned them into $1 million canvases that were sold at the Gagosian Gallery. And the litigation was ongoing for many years. He lost at the trial court stage. But yeah, if you look at these images, I'm sorry?
I thought Richard Prince won.
He lost at trial court, but won in the circuit court on appeal, all right? So he wins on appeal. And actually, if you read, there's a series of cases in the Second Circuit. So earlier cases involved Jeff Koons, and they're fun to read because there it's like, well, this guy's a chiseler. He's ripping people off. He makes $367,000 on his work. He's stealing the stuff from other artists and not paying for it. And then you get to carrier versus Prince, and there's this paragraph that sounds like, I can't use the crude term, but he's enamored, very infatuated with stars. And he's talking about how his campuses are, sell for $1 million, and Beyonce and Jay-Z were at the opening, and this is a completely different market. So it really goes to the fourth factor. But it's a problem. That case is a problem, and precisely the way the Seventh Circuit criticized it for that. Its transformativeness run wild. And it used to be, in fair use case law, you'll see what, shifts in what judges regard as the most important factor. So for a long time it was the market. After the Nation versus Harper and Rowe, Supreme Court said market impact, most important factor. And if there was any market impact, you were cooked. Now we've got this notion of transformativeness, and if you find transformativeness, you win, it seems. Can I just read one thing that Laval wrote? So he's definitely responding to the Seventh Circuit, and he's definitely concerned about this issue. And there's a way in which, much like after the Salinger case, in which it created a series of precedents in which it was hard to use unpublished works. In fact, the Second Circuit, misreading the Supreme Court, said, well, if it's unpublished, kind of de facto assumption against fair use. And that turned into a problem that resulted in an amendment to Section 107 that said you can use unpublished works. So Laval, I think, is trying to fix the Carey-Prince problem. And he says this: the word transformative cannot be taken too literally as a sufficient key to understanding the elements of fair use. It is rather a suggestive symbol for a complex thought, and does not mean that any and all changes made to an author's original text will necessarily support the finding of fair use. So, and in a footnote, he makes clear he's responding to the Seventh Circuit. So, yeah, that case is a problem. Obviously, for a photographer, it's a big issue. Musicians and photographers are getting, they're the big losers under the current Copyright Act, and they're the ones driving a movement towards change, but I have no idea how long that's going to take. Anyway. Carrie, you had a question?
Yes, this is fascinating. I have a question for our
Oh, great, good.
Yeah, well, I was just curious about the classrooms and workshop spaces that you had created, and they seem pretty awesome to me. And so I was wondering what kinds of policies and procedures you have in place around their use and scheduling, because you said it's possible for people to book those for an entire semester?
Well, if you're teaching a credit-bearing course, then yes. But again, we haven't run into the problem where anyone has asked for anything that conflicted. So we don't really have any precedent for that yet. But right now, we do give priority to those types of courses. And we have 2 of them right now. So,
okay.
as far as considerations for things like events, though, we try to really step away from closing the space down entirely, and we don't allow events during finals and midterms preparation weeks and things like that. We also don't allow students to book rooms for more than 2 weeks out or for an entire semester at a time themselves. And because we use LibCal, we just build that into the booking mechanism, so we don't have to think about it.
A quick follow-up, if I may. I'm curious to know, I know you said your campus teaching center was one of your partners, and I wondered if you'd ever thought of working with them to incentivize the use of those learning spaces for your faculty, and if so, what do you think that would look like?
Well, one thing we've been talking about lately is micro-credentialing some of the workshops, and so we are piloting a badge formats GIS MOOC. And that's something that we're working with the Kano Center on.
Which is that?
Which is the Kano Center for Teaching and Learning, yes.
Right. Okay, cool. Thank you.
A quick question,
Sure.
Julie. What types of adaptive technologies have you guys incorporated into those rooms? Is there anything, track mice and such for students with, no, okay.
I am sorry to say no.
Okay.
We do have an accessibility statement on the One Button Studio, but as far as additional technology, that's something that if a request came in, we would work with a different unit to address that.
Okay.
Yeah, I think, because it's never come up, it hasn't been an issue.
Right.
I'm sure everyone would say, yeah, we'll meet that. No one's going to say, like, no, if someone wants adaptive technology, we're not going to buy it for them.
Sure.
But I have a feeling that we would probably be able to find whatever we needed if it came up.
Thank you.
While you're up there, I had a question that I'm going to ask at the beginning of your presentation. You had mentioned that sort of your have so far found your efforts at sort of raising awareness among faculty to be less than ideal. Can you talk a little bit more about that? Are you brainstorming new strategies for increasing outreach? Because here, similarly, you know, we're now in our 5th semester of our public communication program, and that's been kind of a struggle as well, is just kind of getting the word out. It's one thing to go to a department meeting and tell everyone about everything that we're doing, and everyone is very polite and go ahead, and then, but I mean, it's entirely another thing to sort of stimulate engagement and actually have meaningful awareness raised. So what are you planning to do there, do you think?
Sure.
I did want to also sort of mention related to that, that capacity is something that we are trying to be really mindful of. So while maybe we need to work on increasing awareness, we don't want to increase it so much that we have to turn people away, or we certainly don't want to do shoddy work. So.
I think as far as building awareness goes, I mean, like Julie said, we hover somewhere near capacity. Like, I don't think there's any point when any of us is sitting around with nothing to do. But as far as actually reaching out to departments, I think that one thing that we have started doing a lot better is working with subject selectors as the sort of liaison to particular departments. Also, I don't think there's been any marketing thing for us that has worked better than grad students. One grad student comes in, you fix one problem for them, suddenly you have 15 from that department that are marching in over the next couple of months. And then the faculty are in there too, maybe mediated through the grad students. But that's definitely been the most successful outreach so far, which leads to somewhat of a biased population that we serve as well. We're very well represented in biology and ecology. We're very well represented in political science. We're not so well represented in business, just because we haven't really gotten someone that really, you know, has evangelized us the same way that some of the other grad students and junior faculty have. Yeah, I mean, I think I think the capacity issue does come up periodically. It's that, you know, at some point we're going to have to start saying that's too big of a project. We can't really work on that. Unfortunately, when we have had to say that, it's been a really big project, something that should really be funded. But I think those are probably the bigger channels that we try to work through. Yeah, there are a couple of other CDS Notre Dame people that might have something to add. Alex, anything?
I mean, the only thing that I would add to that is that along with different departments, we're seeing impact from other centers on campus.
That's true, yeah.
That aren't necessarily very well funded, but they do have a lot of work that they can help with. And so in that sense, we're able to actually help develop their skills so that they can do part of the library work and then shift the project over to our systems as needed. So that would be the only addition that I would have.
And in some cases, the centers that are very well funded but don't have a skill that we have. Like, I do a lot of work for our Center for Social Concerns, they're not hurting for funding. And they don't have anybody that's sort of tech-minded, really. So we end up collaborating with them pretty frequently.
If you could go back, what would you do differently, knowing what you know now?
Yeah. We did everything perfectly.
Wow.
No, I mean, there are little hiccups along the way, like maybe not spending quite so much time prepping for data management services that didn't really appear. I think from the get-go, maybe having a slightly more formalized relationship with the pre-existing library structure would have been useful. We came in we're sort of divided amongst digital and analog, for one of the better terms, subject selectors and developers more than anything else. And we're sort of in between, but we didn't really push that we kind of are on both sides. We sort of stayed over with the developer world, maybe a little bit more than we should have. But yeah, I think those are probably the big things that I would think that we could have done a little bit better, fitting into the institution slightly more effectively than whatever the first thing I said was.
Data.
Yeah, data.
Lance, I was going to ask, what would you counsel a student whose paper did get taken by a paper, like I mentioned before? I'm just curious to take this question and now take it to the other side.
Yeah, I mean, here's an issue there. I mean, one, I would, well, first, the IRs need to, I think, use the Creative Commons licenses, and the ones that Eastern Illinois proposed are, I think, is the right default one. So the, attribution, non-commercial, non-derivative. So, copyright's automatic, and you can, but in order to enforce it, you still have to register it. I didn't talk about all that, but it is automatic. This actually happened to me with my dissertation. I put it open access on ProQuest, and then I started seeing chapters on paper mills. And what I did, and all you really can do is send takedown notices or send notices to the companies that are doing it, and, make some threats. But, my sense was that those companies, while unscrupulous, are somewhat scrupulous, in that they don't want to draw too much negative attention to themselves. So all you can really do is send a takedown notice to the company saying, and under the Digital Millennium Copyright Act, what you have to do is, and any website should have a notice, a place where you can submit takedown notices. It's required by the DMCA. And we've got to assert that you are the rights holder, that this is your work, that you regard their use as infringing, and so on. If someone doesn't cooperate, in my experience, most will, then you've got problems, because copyright infringement is actually difficult. You still have to register the work, even though copyright protection itself is automatic. Enforcement requires registration for a period of at least 3 months, and the current wait times are over a year for getting something registered. So you've got to wait, and if you haven't registered within 3 months of publishing the work, then you're not really eligible for statutory damages and attorney's fees, which means all you've got is the commercial value of that paper. And I don't care who you are, unless maybe one day, you're a famous scientist or something. Even then, the commercial value is going to be really limited. So enforcement is a problem. But people I think are so generally anxious about copyright that you get pretty quick compliance if you just send a takedown notice. And companies like that are already, I think, feeling exposed by their own lack of scruples. So I think they're just not going to want any unwanted attention, and they'll take it down. So. Yes.
Yeah, actually, I had a follow-up. I was at the last conference here and really liked your talk, and I'm at a medical school, and I'm a professor, do a fact sheet on dosing for like an emergency department, and the publisher took it and tried and changed it a little bit, and they changed fundamentally some of the doses in there, which is dangerous, and because we had put a Creative Commons license on it, but they changed it and they were trying to sell it, and I called up the copyright office to see if I could expedite a registry so that way we could give a really strong takedown notice, and they were very helpful. I don't know how often they do that, but they did. In a month we had at least the registration number and say it was going through, because they were very concerned because it was a public health thing, and that took it down real fast. So.
And did you have to pay extra for the expedited, or
we didn't, because we were still in 3 months of
okay.
publishing,
Okay,
so we
good.
were okay, but I don't know if it had been after that, they might have.
Was this part of a larger work, like an article or something? Because
No, it was just a fact sheet, like
Okay.
of dosing for quick reference for ER doctors to dose for children on drugs, which is based on weight, which is what.
Okay. I would actually wonder about how copyrightable that is.
It's true.
And it's another thing to note is that the registration you get from the Copyright Office is simply an assertion that you own the copyright. If that doctor wanted to tangle with that publisher, one of the questions, threshold question, would be the one I suggested today: is that thing even copyrightable? But that's a fact. That's a great example. There.
So Nats, the 10% one chapter rule, I love that, and it's gone now.
It's gone.
So I was wondering about the rule that governs how long materials can stay up in an LMS or an e-reserve system. Do they still have to be taken down when a class is not in session or after one's cycle?
Look, if I mean, I think as long as you get, I think it depends on your risk, the level of risk you want to talk about. I mean, some best practices might suggest that should go down, come down, or at least go quiet, be sequestered somehow when the class is being taught. And obviously, if it's only available to, to currently enrolled students, that's going to be the case. But you want to make sure, though, I think more important is you want to make sure that the students who are in that class can't get back to that content and couldn't have downloaded it. You want to cut them off, I think, is the more important thing, so that that site doesn't become an ongoing resource for them.
I actually have a question on that too.
Okay.
Because they're interpreting some of their courses to be longitudinal courses that
Okay.
cover 4 years. What would your reaction be to that?
Then that's fine, I think.
Okay.
I mean, the TJAC wants you to take it down when the class isn't being taught, which is just plain inconvenient and stupid. And I mean, also that was 2002, so I think we have a different sense of stuff now. I mean, there's a way in which the TJAC just doesn't really work. Period. It's hard to meet all those requirements. Certainly most colleges aren't going to be able to meet it. A lot of research universities would have problems meeting it. Not all research universities have coherent copyright policies that protect copyright, or someone in a job like mine that's providing instruction about copyright. Those are all some other requirements. So I think what we have from the TJAC now is a statement from Congress that distance education is important, and that helps enhance the reliance on fair use. I think that's what it does for us practically. So whatever you're going to do outside of those very specific requirements, that's more a question of risk assessment and how strong you think your fair use case is for each of the things you're making available on that site.
I just have a question for Matt and Julie. In the beginning stages of the Center for Digital Scholarship at the University of Notre Dame, did you ever survey the faculty to find out what projects they had in the closet or had?
Neither one of us were part of that. I've seen the
I see.
documentation
Okay.
that it was done.
Yeah.
I don't have any details on what it came out other than GIS was listed as one, and I think text mining was listed as the other thing. Chair, I think you were around for
I was on a group, there was a subcommittee of our university committee on libraries that was put together to survey a number of different people on campus and put together what sorts of needs were out there and what sorts of needs were being fulfilled in various ways. That's how we learned that, there were 3D printers on campus, but they were dedicated for use to certain people in certain departments, and so we were able to say that there was value in having those sorts of things for anyone who wanted to walk in.
Yeah, so not only faculty, but the departments are on the campus too, to find out what hardware and software they may
Yep.
need to throw into the fold.
Exactly.
Okay.
Yeah.
Okay, thank you.
Yeah, you're welcome.
This is great. I get to not actually answer the question.